before the court is State versus Vaughn, and each side will have 15 minutes to present their arguments, and as the appellant, you may reserve up to 5.
I would ask to reserve 5 minutes for rebuttal. May it please the court, opposing counsel, Donald Gallup on behalf of defendant appellant Jamall Vaughn. Normally I don't go into the statement of facts, but I think it's important in this case because obviously the facts of the case are horrifying, about as bad as it gets. Having said that, we have to remember that Jamall Vaughn at the time of this brutal crime was 14 years and 1 month old. Had he been 5 weeks younger, there's no way this case could have ever gotten out of juvenile court. Having said that, the record has many allegations that the 19-year-old Sean Ford, they say persuaded, some might say intimidated, Jamall Vaughn to go to the Chauvert's house. Obviously Jamall Vaughn didn't know these people, had no issues with them, no problems with them, and Sean Ford had extensive history and a lot of personal animosity towards the family. Keeping that in mind, there are 3 assignments of error before this court, and 2 of them involve the bind over from juvenile to adult court. This is a case that should have been resolved in juvenile court. Again, he was 14 years and 1 month old. We are challenging the statute. We do think that it's a plain error, but however it was challenged in both juvenile and adult court. We had litigation regarding this, trying to supplement the record because there was a missing order that has been found and supplemented. The most important, I think, the crucial assignment of error is actually assignment of error 2, because looking at the record, we hear the prosecutor say, well, he had prior contact with the juvenile court system, and it doesn't matter what that contact was, that justifies, that allows for bind over to adult court. And that's not what the statute says.
In his words, it doesn't matter what.
That's in the record that says whatever, because we never hear what the prior juvenile case was. We never see a journal entry. We never have a case number. We're never told what the prior contact was for.
But there was no objection or any.
That's true.
Okay.
No, that's true. But at some point, I believe the juvenile court judge suggested it's a misdemeanor. And as we know, under the statute, these are not discretionary statutes. These are mandatory statutes that have to be complied with. It has to be a Category 1 or a Category 2 offense. We're talking about major felonies. We're talking about murder, rape, robbery, arson, things of this nature. There's no misdemeanor that would qualify as a Category 1 or Category 2 offense that would be prior contact as the legislature intended in Title 21. That's a pretty significant error, especially when we have someone who's 14 years and 1 month old who quite likely was threatened, persuaded, intimidated, whatever word we want to use, into accompanying the 19-year-old with an extensive criminal history to go over and participate in these murders. And I say participate, the coroner said, yes, there was a stab wound, but that was most likely post-mortem. It wasn't the cause of death, something that Sean Ford wanted Jamall Vaughn to do in order to make him part of the crime. Again, there's no suggestion that Jamall Vaughn had any animosity towards any of the people here, didn't know him, had no idea what was going on, but knows that Sean Ford, who's 19 instead of 14, and who's a rather intimidating individual, said, come on, we're going over here. The prosecutor made a lot of issues like, well, why didn't the 14-year-old call the police, or why didn't the 14-year-old run away? 14-year-old doesn't even know where he is. He was taken there. 14-year-old's not going to call the police on a 19-year-old that he's going to see the very next day in school. These are things to consider when you think about the amenability of Jamall Vaughn. But the question of the statutory compliance of 2952.12D and also E5, the statutes weren't complied with. If the juvenile court is correct and it was a misdemeanor, and again, it would be nice if we had that in the record, what was this prior contact? Was it a truancy misdemeanor? Was it a disorderly conduct? We don't know exactly, but clearly it's not a Category 1 or Category 2 offense that is required to bind over a 14-year-old to adult court.
Well, we don't know what it was, how do we know that?
Well, you have the juvenile court says it's a misdemeanor.
Oh, okay.
So they say it's a misdemeanor. I mean, I doubt it could be a misdemeanor manslaughter or something like that. Again, the record is not clear on this. It should have been sketched out a lot better. As we know, there were documents missing from the bind over. We had to spend a fair amount of time tracking those down. I thank the prosecutor for helping us with that. But the 2952.02 BB is actually defines what category 2 offense is. I think AA defines what category 1 is. There's no suggestion that either of those statutes were complied with. So really, even if Jamall Vaughn was in juvenile court for some misdemeanor or truancy or whatever it might have been, that doesn't count as prior contact when you're evaluating a bind over to adult court, even on a case as horrifying as this.
Well, this phrase had prior contact with, it was just sort of a casual way of describing what?
Well, this wasn't the first time that he was in juvenile court, and therefore bind over to adult court is appropriate under the statute. But
would his record as a juvenile have been admissible? Why was it not?
Your Honor,
I'm
there's
asking
things-
speculation.
Your Honor, that's a great question. That is a really good question as to why the prosecutor didn't say he has a prior conviction for, or a juvenile adjudication for whatever it is. And here's the journal entry that we're going to proffer into the record.
All right, now let me play devil's advocate. He didn't deny that he had a prior record.
Well, I don't think the 14-year-old really knows what he has. You know what I mean?
Okay.
The 14-year-old.
Well, he's talking about his attorney.
His attorney.
Oh, that's
He
true.
didn't deny.
Well, that's certainly
Okay. I don't want to
true.
waste any more time with your.
No, I understand.
Go ahead.
I understand. But this is a very serious matter. And I mean, and again, there's other things. The juvenile court says there wasn't even a competency evaluation done. Now, I mean, some of these things might be brought up in post-conviction rather than direct appeal. But it's clear when you have something this serious, we want to follow these statutory mandates. When you're talking about sending a 14-year-old over for double aggravated murder to adult court, you know, you could say the defendant didn't meet its burden, but the prosecutor has a burden of showing that these statutes were complied with, and then saying, oh, well, it doesn't matter if it's a misdemeanor or not. Well, that's a misstatement of the law. It does matter. If it's a misdemeanor, there's no way Jamall Vaughn gets bound over. And the only thing we have in the record suggests it's a misdemeanor. And so, yes.
Okay, then explain to me the difference between 2151.12 E5 and D6, and 2151.12 D6.
Well, both of these deal
That
with.
seems to be the crux of the matter here.
That's it. That's exactly right. Well, D6 says that you can relinquish jurisdiction if the child was awaiting adjudication or disposition as a delinquent child. So if you had another, you know, if you had a pending case that was open right then and there, or I guess it could have been in another county or something like that, then that certainly would comply with the statute for bind over. The other statute is this prior contact, but it has to be prior contact of a category 1 or category 2 offense, which is defined by statute. And we're talking about murder, rape, arson, robbery, burglary, what we would think of as major felonies in
Okay.
adult court.
And under which statute is the juvenile court binding over?
Well, I believe in the order, it uses the 2152.2D and E5. And the juvenile court mentions the prior contact. There's a dialogue going on with the prosecutor saying, oh yeah, you know, it was a misdemeanor. I can't remember if it was the juvenile court judge who says, oh, it's a misdemeanor, or the prosecutor says he has a misdemeanor. But at some point, the prosecutor says, well, whatever it is, it's prior contact with the juvenile justice system, so we can bind him over. And that's not what the statute holds.
So there's no evidence that he was under community control, or he was on probate or parole for a prior delinquent child adjudication or conviction?
Not in this record.
There's no record anywhere in the juvenile court record?
Not that I saw. I went through quite a few number of pages. It's a fairly substantial juvenile transcript. And the only thing you hear is, it was a misdemeanor. I mean, you know, I guess, I don't want to say there's no misdemeanor that could qualify. I don't know if a misdemeanor, you know, a vehicular homicide might have complied or something like that. But we're just guessing. You know, again, we have a 14-year-old, 14 years old and 36 days of age. and we're transferring him to adult court for a double murder, we shouldn't be here guessing what if there was a misdemeanor conviction for truancy or littering or whatever it was.
Counsel, you're in the rebuttal.
I understand, I'll reserve my balance.
Mr. Casey, just give me 1 second here. I apologize. All right, you have your 15 minutes.
May it please the court, Richard Casey representing the state of Ohio in this case. What the record shows is that, and this is in Court Exhibit A from Juvenile Court, Dr. Webb, the juvenile court psychologist, states at page 8, Vaughn has had 2 previous delinquency referrals to the court, both misdemeanor charges occurring in March of 2012, one for criminal trespass and the second for chronic truancy. Now, what the assignment of error is, assignment of error 2, the most important assignment according to Mr. Gallup, is that the bind-over order, not even the bind-over order, the guilty plea and sentencing are void ab initio. That isn't even talking about the bind-over order. What's alleged to be void is the guilty plea and the sentencing, presumably the judgment of conviction.
Well, don't we have to get past that first? Because ordinarily, if you plead guilty, you're waiving everything.
Well, of course. So the guilty plea is a forfeiture of preceding errors that do not go to the knowing, intelligent, and voluntary nature of the plea. That's State versus Quarterman.
Except in a situation that they're arguing that there's no jurisdiction.
Well, if it's void ab initio, that means there's no subject matter jurisdiction. So who is lacking subject matter jurisdiction here? Judge, the General Division Judge, Judge Teodosio? Let's say for purposes of argument that what the real claim is that Judge Teodosio did not have subject matter jurisdiction to issue this discretionary bind-over order because Vaughn had 2 misdemeanor referrals to juvenile court in 2012, and Judge Teodosio put in your order that he had prior contact. I'm at a loss to understand how that translates into a loss of subject matter jurisdiction. It could be an argument that's an erroneous exercise of jurisdiction, but that's not what's in this assignment of error.
And that's for juvenile court. But what if it is with, I'm sure you're going to get to that, what if the argument is this, the lack of subject matter jurisdiction of the adult pleas court?
Well, if there was no bind-over order at all, the General Division would not have subject matter jurisdiction. But there was a bind-over order, so the issue has to devolve into the bona fides of the bind-over order. If the bind-over order, even if it's erroneous, let's go that far, that doesn't rob the General Division Judge of subject matter jurisdiction. So, I think what the issue has to be is the bona fides of the bind-over order. And that's really not even the argument made here. So he has 2 misdemeanor referrals to juvenile court, and then the argument is that irrevocably taints the bind-over order. I'm sorry, I don't see where that follows one from the other. The statute, the bind-over statute, says any relevant factor. His prior juvenile record has to be a relevant factor. And the statute, I think, as was pointed out in questions, it talks about factors that would point to some prior contact with the juvenile justice system.
Is that the language of the statute, or is that a paraphrase of the statute?
Well, one of the factors is the child previously has not been adjudicated a delinquent child. That's a factor militating against transfer. And one of them in favor of transfer, the results of any previous juvenile sanctions and programs indicate that rehabilitation will not occur in the juvenile system. So there's plenty of room to interpret that statute as making prior contact relevant. But even if we're not, even if we can't, Judge Teodosio should not have considered what's in Dr. Webb's report. What is the effect on the bind-over order? Is it harmful or is it harmless? If you read her order, the factors that Judge Teodosio ultimately relies on are, the personal characteristics of Jamall Vaughn, the heinous nature of these offenses, and her conclusion that he cannot be rehabilitated in the juvenile justice system. Now, I submit that if he did not have 2 misdemeanors referrals in 2012, that does not mean she would have said, fine, we'll keep him here, we can rehabilitate him here. It just doesn't follow. So I'm submitting to this court that it was not error to consider those, and 2, if it was, there's no way it could have had any type of decisive impact on Judge Teodosio's ultimate decision. Now, Mr. Gallick was saying that misdemeanors are in Category 1 or Category 2 offenses. I'm looking at the statute and I'm not seeing anywhere where it says that a prior record or prior involvement has to involve Category 1 or Category 2 offenses. You need that for the bind-over. He was charged with that. That's where it's important. What?
So it's not past offenses we're talking about any offense, including the one that is the subject of the bind-over.
Well, to make the juvenile eligible for bind-over, depending on the juvenile's age and the seriousness of the offense. If it's a Category 1 offense, I think they can be bound over at 14, I think. But there's an age limit that the court has jurisdiction to bind over, depending on the seriousness of the offense. That has nothing to do with prior adjudications or referrals in juvenile court. That's simply the authority to bind over in the first instance. Could be mandatory if they're old enough. 17 years old, Category 1, that's a mandatory bind over. That was quarterly. Vaughn, being as young as he was, it's discretionary. So we have a hearing. Is he amenable to rehabilitation in the juvenile justice system? That is the ultimate question. And whether or not he had 2 misdemeanor referrals is not the decisive point in that decision. Certainly, any error does not take away subject matter jurisdiction from the juvenile court.
Well, I'm not sure I understand why we're talking about subject matter jurisdiction.
Well, if we're talking-
Because juvenile court always has subject matter
Well, I was talking about subject matter jurisdiction because that's a sign of error too, void ab initio. Okay, so the guilty plea and sentencing. So if we're talking about the subject matter jurisdiction of the common pleas court, there was a bind-over order, so,
But the
Again.
only way the common pleas court gets jurisdiction, unless I'm missing something, is through a valid bind over.
right.
So if the bind over is invalid, then doesn't the common pleas court lose jurisdiction? It never had jurisdiction to begin with of the juvenile.
I was not stating this precisely now. We have to be looking at the bona fides of the bind-over order.
Okay.
So,
But I thought you were saying that didn't affect the jurisdiction of the common pleas court, if it's erroneous. I'm sorry, maybe I misunderstood you.
it could be erroneous, but, well, let me try to refine this further. There could be error, then the question's going to be, is it reversible error? Was it reversible error to Judge Teodosio? Was it harmful error because Vaughn had 2 misdemeanor referrals in 2012? That, I think, is the ultimate question. But it does not that does not involve subject matter jurisdiction of either court. We're not talking about void ab initio.
So you're saying the only way the trial court, common pleas court would not have jurisdiction, subject matter jurisdiction, if there was never a bind over period. So an erroneous bind over doesn't impact the subject matter jurisdiction of the common pleas court under your hypothesis.
Erroneous meaning reversible.
Well,
No,
yeah, we're always only dealing with reversible
Well,
error in the Court of Appeals, obviously.
Yes, so there could be an error, I'm not conceding that there was, but for that to affect the authority of the common pleas court, it has to be reversible error. Again, the bona fides of the bind-over order is the issue.
Well, I guess I'm thinking, when you say reversible error, obviously, if it's some kind of like, typo or grammatical error or something like that, obviously that's harmless. But when you're talking about, statutory procedure and
Mhm.
factors that have to be found, and, I'm not saying that's the case here, I'm just saying, if you have, certain required procedures and certain required statutory factors, and if they're not found or they are erroneously found, wouldn't that affect the jurisdiction of the Court of Common Pleas?
Again, the bind-over order has got to constitute reversible error.
Okay.
We're not talking about a strict liability situation here, where if the court considers one thing that it shouldn't have, ipso facto, that bind-over order is no good.
So,
And, I'm sorry.
so essentially you're saying that we're supposed, instead of looking at a mandatory, we're looking at a discretionary transfer.
Yes,
Under 2152-10B. We're
Yes.
supposed to look at the factors in 2152-12. And 2152-12. What is it, E5?
E5
Okay.
has not been the child previously has not been adjudicated a delinquent child.
Okay. Simply that.
Simply that.
Okay.
And if you read Judge Teodosio's bind-over order,
That's what she said.
she lays it out in pretty good detail. He is not amenable to rehabilitation in the juvenile court system. That's what she ultimately has to decide under the statute, and she did decide that. Now, this argument of 2 misdemeanors, the state's ultimate position is, what difference does it make? It does not make a difference. Right or wrong?
Because he didn't qualify under 2152-10A. So we're looking at 2152-10B.
What statute were you citing?
215210, A is mandatory, B is discretionary.
B is discretionary.
So we're saying if he didn't qualify under A, the mandatory one, he does qualify under B, the discretionary one.
Well, it couldn't be mandatory because he wasn't old enough.
Right.
So it had to be discretionary, that's why we have a hearing,
B is 14 at the time of act charge, so.
yeah. So it has to be discretionary.
And we've asked so many questions, your time is up, I apologize. Do you want to sum up real quick?
I just want to say one thing real quickly. There was a claim here calling into question Jamall Vaughn's competency. There was never a request for a competency hearing. And when the court looks at the sentencing transcript at page 22, Judge Parker asks defense counsel specifically, are you claiming he's incompetent? No. Are you claiming he's insane? No. So this is a big red herring, this issue of, you know, the poor 14-year-old doesn't really know what's happening to him. Okay, with that, thank you.
Thank you.
Very,
You have 5 minutes.
very brief. There's a case that I cite, State versus Brown. I don't believe it's this district, but it's 2014, Ohio 314. It says that if there's a bind over and it doesn't follow all of the statutory requirements, that it's void. I believe it says void. I don't think it's voidable. I believe that it's void. You have to follow these bind over statutes, or the bind over order is not appropriate. And I wish I had the full Title 21 statutes here. As the court knows, they're very long and they all refer to one another, which is why we keep bouncing around from, you know, point 10, point 12, and all these different provisions. But I believe, if I'm not mistaken, that 2152.10, which I believe Judge Schaefer, you mentioned too, says that a 14 or 15-year-old was previously adjudicated a delinquent child for a Category 1 or Category 2 offense. I don't have the whole statutes here with me, but, you know, and I think that's why we're having this issue of, well, he had a misdemeanor adjudication, or Dr. Webb said he had a truancy or trespassing, so there you go, what difference does it make? I think the whole statute says adjudication, previously adjudicated delinquent child for a Category 1 or Category 2 offense. I can't tell the court 100%, though, because I don't have the full statute. I'm only citing certain provisions of the statute, because they're very lengthy statutes.
But that would be the mandatory transfer part.
So you're saying the discretionary does not have that
Under
provision?
Section B, the discretionary part, it doesn't say that.
It just says any contact with the court system?
It says unless the child is subject to mandatory transfer, which in this case,
Yes.
he's not, because he hasn't had a Category 1 or Category 2.
Yes.
It says that if the child is 14 years of age or older at the time of the act, which he is, the act would be a felony if committed by an adult, which it would. The child is eligible for discretionary transfer to the appropriate court for criminal prosecution. In determining whether to transfer the child for criminal prosecution, the juvenile court shall follow the procedures in Section 2152.12 under discretionary transfer. So it wouldn't be a mandatory transfer under A, it's a discretionary transfer under B.
So then it references 2151.12, I'm guessing E. I don't have that statute completely printed out either, so I'm wondering if that has a Category 1 or Category 2 provision.
It says in considering, under D, in
Yes.
considering whether to transfer a child under Division B of this section, which is what we're considering a discretionary transfer, the juvenile court shall consider the following relevant factors and any other relevant factors in favor of a transfer under that division. So it says you have to consider these ones under here. And the one that you're referring to would be the one, at the time of the act charged the child, to consider whether at the time of the act charged the child was awaiting adjudication or disposition as a delinquent child, was under community control, or was on parole for prior delinquent child adjudication or conviction. Doesn't say it has to be, it just says you have to consider that.
Well, I think that would be the negative in this case. So he didn't have, I mean, maybe, you know, in 2012 he had a truancy or trespassing, but I don't think he was under any community control sanction at the time of this offense. And I do know that there, I see from my brief that Dr. Webb does reference that case. We don't know much more about it. Judge Parker in his sentencing says he has no criminal record, but obviously there's a lot of different conflicts going back and forth here. I think that, Judge Carr, I think your position is the argument I'm trying to make as far as if there's no bind over, then the adult court has no jurisdiction. Obviously, juvenile court has jurisdiction at all times. The question is, were the discretionary bind over statutes followed? And the State versus Brown case, which again, I don't think is from this court, but it says if they're not followed, then the bind over order is void. And that's the argument I'm trying to make here.
Well, and I'm just trying to understand, I'm not taking a position.
Of course.
just to understand.
No, I
I'm just
understand.
trying to figure out which jurisdiction we're talking about and how do we get that jurisdictional hook, and if the jurisdictional hook is not there, what are the implications or the ramifications of that?
Exactly. There's no argument being made that the juvenile court can't have authority over a 14-year-old. Obviously, it can. Really, everything we're attacking in assignment of error 1, and assignment of error 1, we're attacking the statute both facially and as applied. But assignment of error 1 and 2 is attacking the bind over order. There's obviously assignment of error 3 where we think that some sentencing factors weren't considered, such as the statement of the principal offender. The sentencing judge says, I'm not going to do that. And there's some other matters as far as him being 14 and 1 month old at the time of the offense. Seems like that's something that should have been considered in sentencing. Those are minor points in a very serious case like this, but I thought I'd be remiss if not mentioning something in the third assignment of error. Unless the court has any other questions, I would thank the court for its time.
Thank you. Thank you both for your presentations to the court. The court will take the matter